Hello everyone. In my series of videos, I have been discussing the Limitation Act, and in my last two previous videos, I have discussed sections 1 to section 11. That is the application of the act, definition and different terminologies, the limitation of suits, appeals and applications. In my today's video, I will discuss about part 3 of the act. Part 3, namely the computation of period of limitation, it is covered within section 12 to 24, out of which section 12 to 15 deals with the exclusion of the time. In this video, I will focus on the principle of exclusion of time, that is the limitation period, which is explained in section 12 of the Limitation Act. However, before we start the section, let's first understand what is the meaning of the exclusion of time period, especially in reference to the Limitation Act. As of now, we have understood the meaning of Limitation Act. It means the limited period to file a lawsuit. Especially in case of civil dispute, the parties have to strictly follow the limited period of time. Otherwise, they will lose their rights. Very simple. So what is the conclusion? The conclusion is file a suit within the limited time as prescribed in this Limitation Act. Now the question is, if we have the limited period of time, then how will we calculate it? What date to what date will be calculated? Is there any exclusion of the time period? Then in order to get all these answers, we have to focus on section 12, which discusses about the exclusion of the time period while calculating the time period to file the review, revision or appeal. So let's get started, guys. See, any time period so mentioned under this section will be excluded and added to the prescribed period of the limitation. Here, before we move forward, we need to understand what prescribed period of limitation means. Prescribed period means the given time period. For example, if the limitation period to file a review petition is 30 days, then the prescribed time will be 30 days. Now, we get back to section 12, which discusses the exclusion of certain time period during that prescribed time. In order to define the concept of exclusion of the time period, which is in accordance to section 12, the 4 clauses have categorized it in different situations. The first clause deals with the day of reckoning. It means the day on which the cause of action has arisen. Clause 2 deals with the time requisite to obtain the copy of judgment. It is very clear. I mean the time period that the court takes to give you a copy of judgment. Third clause deals with the time requisite to obtain a copy of decree or order. It is also similar to the second clause. The fourth is the time requisite to obtain a copy of award. It is also similar to the second and the third clause. Now, to make it simple, let's discuss these clauses with some examples. Focusing firstly on the day of reckoning, as I mentioned in clause 1. That is the day on which the cause of action arises. Let's understand it by an example. Suppose there are two parties, A and B. Both of them have made an agreement to do a business in partnership. After a month, say 19th of September 2020, A cheated on B. That is, A has breached B. Now, as per the contract law, B has the right to seek for legal help to restore his right or loss. But as per the Limitation Act, B has to file a lawsuit within 90 days against A. In such a condition, the question is from which date the calculation will start. To get this answer, we need the help of section 12, clause 1, which says that the day of reckoning which is nothing other than the day on which the cause of action arises, is to be excluded. That is, the cause of action has arisen on September 19th. Okay, so September 19th will be excluded and the calculation will begin from 20th of September 2020. Moving on to the second clause, which says that the time requisite to obtain a copy of judgment will be excluded. Again, it's confused, right? Okay, let's take a simple example. Suppose there are two parties, A and B, whose case is under trial in court. On September 19, 2020, the judgment is passed in favor of A. Now B wants to file a review, revision or appeal against the judgment. As we know, to file a review, revision or an appeal, the limitation period is applied. So, say B has 60 days to file a review petition against that judgment. Now again the question is, from which date the time period will be calculated? As stated above, the day of passing the judgment, that is September 19. Now, in order to file a review petition, B needs a copy of the judgment, right? So, B has to file an application to get the copy of judgment, and B does it and gets it, obtains it after 4 days. Now let's calculate the time period. The prescribed timer is 60 days. The day on which the judgment is passed is September 19, 2020. Application of clause 1 of section 12. Remember the exclusion of the day of reckoning. So the calculation starts from 20th of September. But wait, we have to apply clause 2 of section 12 as well, which will exclude the time taken to obtain the copy of the decree or judgment. So B got the decree or the copy of the decree on September 24th, that is 4 days after the judgment was passed. Likewise, the calculation time will start from 25th of September 2020. So what has just happened? The prescribed period remains the same, but the prescribed period calculation starts from September 25th, 2020. This period has been till 25 September 2020, the time has been excluded. Now we come to the third clause of section 12, which is also very similar to clause 2 only. However, the only difference is of the term of judgment, and in clause 3 is the term decree or order, and the rest of the calculation will remain exactly the same. Lastly, we have clause 4. Again, the method of calculation remains the same as in the second clause and the third clause. Only difference is in the terminology. That is, now it is the award. So what we see in the second clause, it uses judgment, third it uses order or decree, and the fourth is the award. Now we come to the explanation of section 12, which is also very important, especially in calculating of the time period. What does it state? In computing under this section, the time requisite for obtaining a copy or decree or order, any time taken by the court to prepare the decree or order before the application of the copy thereof is made and shall be excluded. Let us take a small example again. Now, A is a person against whom the judgment has been passed on the 1st of January 2020. On the very day has got the copy of judgment. But to make an appeal, A also wants a copy of the decree. It has applied for the copy of decree on the 6th of January 2020, and it has obtained it on the 6th of February 2020. So, by applying the various clauses of section 12, like in clause 1, the day of reckoning will be cancelled and the period of calculation will start from 2nd of January 2012. Then on the very day we have obtained the copy of judgment. That is, we can also file the appeal with the copy of judgment, but we have waited a certain period of time to obtain a copy of decree also to file the appeal. That from the 2nd of January to the 5th of January, that the time period that we have delayed will not be excluded from the prescribed time. The time period from 6th of January to the 6th of February 2020 will be excluded and will be added with the prescribed period. I think it is clear. So the second, it started running from the 2nd of January 2020 and it kept on running till 5th of January. Then from the 6th of January till the 6th of February, that 30 days time has been excluded. I understand it was a bit confusing, but I still believe that with such clear examples, now it is a bit easier for you to understand section 12 of the Limitation Act. So before we say goodbye and wrap up, we will just give a quick revision as what we have discussed today. Firstly, we have dealt with the concept of exclusion of time periods as raised in clauses of section 12. Further, we have categorized them into 4 clauses. That is the day of reckoning. The second clause is the time requisite to obtain the copy of judgment. Third, time requisite to obtain a copy of decree or order. And the fourth is the time requisite to obtain the copy of award. Moreover, I would like to bring to your attention that through various examples we have understood how to compute the time period with exclusion and addition to the prescribed period of limitation. But it should also be kept in mind that obtaining a copy of decree, judgment or award, the application must be done within the prescribed period, or else the section will not be applied. Also, we have dealt with the explanation of section 12 which further clarifies as to which dates will not be excluded in the prescribed period of limitation. So that's all for today. Hope we will catch up in the next video where we will be discussing section 13 of the Limitation Act. Bye-bye.